about you. Try not to forget my words. When I'm around you, I tend to keep changing my mind. I promise.
All right, so good friend of mine fired over a common law dismissal here, and he's always shooting me over some good information, and I wanted to share it with you guys. This is cause number 9507735. It's the plaintiff would be the Bellow Corp and versus Johnny Johnston. All right, and it's in the District Court of Dallas County, Texas, 14th Judicial District. Order of dismissal. It is hereby ordered that this cause of action is hereby dismissed for lack of jurisdiction, since the subject matter has previously been adjudicated and res judicata does apply and bars the action. Signed this 19th day of September 1995 by a judge who actually has a legible signature to a degree, which is kind of impressive. Most of them write like kindergartners. And here is the brief. Brief in support of the defendant's answers and motions to dismiss. The Magna Carta of the year 12,015 in England started the basis for common law. This law was brought to America when English sovereigns came to the American shores. Common law was the supreme law of the land of America and was thereby our one supreme court of the people, by the people, and for the people. Then came the Constitution of the United States, dated September 17th, 1787, which is still in effect and has never been declared void, and is the oldest written constitution still in effect today, wherein Article 1, Section 1 states, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. In Section 8, it states that Congress shall have the power to constitute tribunals inferior to the Supreme Court. The Constitution had not, prior to this statement in the Constitution being written, since this was Article 1, provided for a legislative Supreme Court, they were and could not, without any doubt, be referring our one Supreme Court in and of common law, which was already established and active in America and the United States of America. It is clear that the Constitution was not setting up another set of courts called legislative courts, and they refer to them as inferior courts, meaning inferior to the already existing common law courts. Our one Supreme Court, Article 1 of the Constitution, did then and there set up legislative courts inferior to the common law courts, and is verified by Article VII of the Articles of Amendments to the Constitution, wherein guarantees that in suits at common law where the value is in controversy shall exceed $20, the right of trial by jury shall be preserved, and no facts tried by a jury shall otherwise be re-examined in any court of the United States than according to the rule of the common law. This set sets the courts of the common law separate and apart from legislative courts, such as the 14th Judicial District, otherwise being a maritime court, in that any case tried in the 14th District can be re-examined by action of appeal. This places the 14th District Court as one of the inferior courts referred to in the Article 1, Section 8 of the Constitution of the United States. Note the difference in a trial by jury in common law as to a trial with a jury in legislative inferior courts. The judge is in the inferior courts and instructs the jury on what they will hear and decide upon and what they will not. There is no such provision in the common law with trial by a jury. The Northwest Ordinance of 1787, which have never been altered by common consent or in any way or manner and presently remains in force. The last words of the introduction or preamble to the Articles of the Ordinance states, "It is hereby ordained and declared by the authority aforesaid that the following articles shall be considered as articles of the compact between the original states in said territory and shall forever remain unalterable unless by common consent. The compact agreement is a federal injunction and is forever unalterable, either by legislative Congress and its legislative Supreme Court and its other inferior courts or the administration. It is protected by Article 4, Section 2, Part 1 of the Constitution for the United States of America, which guarantees the citizens of each state shall be entitled to all privileges of citizens in the several states. Article 2 of the Compact Agreement states that the inhabitants of the said territory shall always be entitled to the writ of habeas corpus and of a trial by jury and of judicial proceedings according to the course of the common law. That the legislative law, statutory law, is in fact an extension of maritime law. The 1946 Administrative Procedures Act, Title V, U.S.C. Section 559, at Sentence 2, requires the administrative law to be in complete compliance with and in conformity to the Constitution for the United States of America, not of the United States of America. And the common law with all its prohibitions, restrictions, restraints, and limitations imposed by its enumerated Amendment 9 bounds and boundaries. The Maritime Code, otherwise known also as statutory law, being administered in legislative inferior courts, 14th District Court, as evidenced by maritime gold braided flag in the courtroom, also acknowledges that when brought inland beyond the high water mark and or first bridge of any navigable river, they must be brought into compliance with and in conformity to the Constitution, again, for the United States of America and subject to the common law. A, saving to suitors. In all cases, the right to a common law remedy where the common law is competent to give it shall also have exclusive original jurisdiction, cognizance of all seizures of land or other waters then as aforesaid made, and of all suits for penalties and forfeitures incurred under laws of the United States Government Incorporated, 1 Statute 77, Section 9A. Third, of all causes of admiralty and maritime jurisdiction saving to suitors, in all cases, the right of a common law remedy, where the common law is competent to give it, 36 Statute 1161, Section 256, Part 3, thus remaining competent. Common law is not extending in reverse of the high water mark and extending to the sea or the jurisdiction of maritime law or to exercise jurisdiction as stated in the Constitution under Articles 1, Section 8, wherein it declares that the inferior tribunals will exercise exclusive legislation as prescribed by Congress over such district not exceeding 10 square miles. Oh man, where have I heard that before? That Derek guy's always talking about that 10 square miles. As may, by sessions of the particular states and the acceptance of Congress, become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislator of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Could that be that crazy guy who keeps talking about armories? Could that be what that Constitution says? Where are your armories? And make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any other department or officers thereof. Legislative statutory courts themselves admit the validity of the common law court in Strauss versus Strauss, STRAUSS versus STRAUSS, 3SO period 2 in D 772 at 728. This case happened in 1941, which states every system of law known to civilized society generated from or had as its component one of the three well-known systems of ethics, pagan, Stolic, or Christian. The common law draws its substance from the latter. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. It is the guide by which we dissolve domestic friction, and the rule by all legal controversies are settled. Whereas we learned that the law of the land means the common law, State versus Simon, 2 Supra 761 at 767, 1884. Justice O'Neill speaks for the court. Taylor versus Porter, 4 Hill 140 at 146. This case happened in 1843. Webster definition of the law of the land at Dartmouth 4 Wheaton 518 at 581 and 582. And Weil, W-Y-L-Y versus Collins, 9GA 223 at 237. This case happened in 1851. Acknowledges the common law and the Holy Bible from which it came, which is the foundation of the common law, is our God-given, constitutionally secured right. The 97th Congress declared the Holy Bible to be the Word of God by joint resolution, Public Law 97-280, 96 Stat 1211. The common law cases tried before a jury regarding Uniform Commercial Code filing have been finally and foremost adjudicated under common law, wherein there is no appeal to this 14th Judicial District Court, since it is very clear that this case has been tried by a jury from which there is no appeal. Thus, res judicata applies, and this court has no jurisdiction to hear this case. The Uniform Commercial Code is specific for all who operate under or within it. To state that they do not know it or act out of ignorance is not a defense, nor does it give rise to action because of the ignorance of the same. The legislative or statutory courts have never recognized that as a defense for not answering a presentment or a petition. If you don't think that you owe something, you make your denial known. Respectfully submitted by Jerry L. Wilkins. We continue on. Regards to all appellate subdivisions of the appellate jurisdiction of the Supreme Court of the United States, et al., to all financing institutions of the United States and their agents, subject et al., the UCC 176357 true bill or UCC 4 affidavit, UCC 3 724855, and the commercial lien. United States of America, Republic of Texas, Ellis de Jure, affidavit of finding of facts judgment. People in and for United States of America for Ellis County, Texas Republic, after reviewing the evidence and hearing testimony, hereby attest and acknowledge the finding of facts to be true, correct, certain, and relevant against the defendants of this judgment, and as follows. Fact, affiant Fr. Johnny Johnston, being a free man character, did charge defendants for fraudulent work or wrongdoing, and did send September 7th, 1994 via certified mail contract P248217655 to the defendants. 1. Complete set of 2 original documents identical to each other in every way, the other retained by Fr. Johnny Johnston, which we, the jury, have reviewed, and says, state of the forum, common law, UCC 1-105, UCC FS 4, non-negotiable, true bill, private agreement means bargain of the practice. In fact, Craig versus Missouri, 29 U.S., 4 PET 410, 433-36. And this case happened in 1830 that he's referencing, with UCC 1 and other certificate documents attached. 2. Fact, defendant did receive proper legal lawful notice and were given adequate time, grace, to respond, plus an additional 294 days to respond, and or deny said defendants have not answered, denied, or responded in any way taught he charges against them, all of them. Documentation is self-supporting in and of itself in favor of Fr. Johnny Johnston and against defendants of this case, FRJJ 95005. 3. The defendants have failed to respond and have admitted to being guilty by their own inaction, and thus are guilty beyond a shadow of a doubt of all charges, allegations brought against them in this matter. Private judgment, lien, and decree. After due consideration and finding of the facts, our one Supreme Court, exclusive to the people, by order of the people, in and for the United States of America, for Ellis County, Texas Republic, finds private judgment, lien, and decree for affiant plaintiff and the same against defendant in the amount of $100 million. They weren't playing. Oh, excuse me. I misread that. 1 billion in silver coin or the equivalent in Federal Reserve notes to be paid immediately in full without further delay to Fr. Johnny Johnston or his assigns at their direction, backed by the full faith and credit of the United States, and further the above finding of facts and conclusions by the jury is not reviewable by any other court of the United States as set forth under the 7th Amendment, nor subject to trespass upon case FRJJ 95005 by the judicial power of the United States. See the 11th Amendment of our national Constitution. So agreed to and done this day, 23rd of July, 1995. There are a number of per curiam, C-U-R-I-A-M. I'm guessing per curiam is witnesses. You'll have to look that one up. I'm on the fly this morning or this afternoon. And says, we, Matthew Tint, a notary duly commissioned and privately bonded by the people in and for the United States of America, for the Republic of Texas, hereby attest and acknowledge that the above juries signed, as jurist, signed, are the ones chosen and have been duly presented with the facts and testimony in the relation to the character of the parties and the facts set forth in this affidavit. Our one Supreme Court common law venue, original and exclusive jurisdiction, a superior court sitting with the power of the circuit and United States of America in and for Dallas County, de jure, Texas Republic, United States of America. Private judgment, lien, and notice, case number JW 95006, in law, not at law. Let's get into this one. To all appellate subdivisions of the appellate jurisdiction of the Supreme Court of the United States, et al., all financial and financing institutions of the United States and their agents subject, et al., the UCC 1176358, true bill of the UCC 4 affidavit, UCC 3732510, and the commercial lien. United States of America, Republic of Texas, Dallas, de jure, affidavits of finding of facts, judgment. People in the United States of America for Dallas County, Texas Republic, after reviewing the evidence and hearing testimony, hereby attest and acknowledge to the finding of facts to be true, correct, certain, and relevant against the defendants of this judgment, and as follows. 1. Fact. Affiant Jerry L. Wilkins, being a free man character, did charge defendant for fraudulent works wrongdoing and did send on September 7th, 1994, via certified mail, contract P248217653 to the defendants, 1, complete set of 2 original documents identical to each other in every way. The other retained by Jerry L. Wilkins, which we, the jury, have reviewed and state of the forum, Common Law, UCC 1-105, UCC FS 4, non-negotiable true bill private agreement means bargain of the parties. In fact, Craig versus Missouri, 29 U.S. 4 PET 410 433-36 1830 with UCC 1 and other certificates documents attached. 2. Fact. Defendant did receive proper legal lawful notice and were given adequate time, grace, to respond, plus an additional 240 days to respond and or deny. The said defendants have not answered, denied, or responded in any way to the charges against them. All of them, documentation is self-supporting in and of itself in favor of Jerry L. Wilkins and against defendants of the case, JW 95006. Number 3. Facts. Defendants have failed to respond and have admitted to being guilty by their own actions and infractions, and thus are guilty beyond a shadow of a doubt of all charges, allegations brought against them in this matter. Private judgment. After due consideration and finding of the facts, our one Supreme Court of the United States of America, to the people, by order of the people in the United States of America, Dallas County, Texas Republic, find private judgment, lien, and decree for affiant plaintiff and they put a nice little stamp over that, and the same against the defendant in the amount of $1 billion in silver coin or the equivalent in Federal Reserve notes, and immediately to be paid without further delay to Jerry L. Wilkins or his assigns and his heirs' discretion, backed by the full faith and credit of the United States, and further the above finding of the facts. Unfortunately, I won't be able to decipher that. By the jury is not reviewable by any other court of the United States except as set forth under the 7th Amendment of the Constitution for the United States of America. Upon case JW 95006 by the judicial power of the United States, see the 11th Amendment of our Constitution. And again, it's the juries. Let's see what else is in here. Okay, this is the defendant's answer. Comes now Fr. Johnny Johnston, Jerry L. Wilkins, and Lakeview Developers Incorporated, DBA Lakeview Cemetery, and without prejudice and reservation of rights, UCC 1-207, and files this answer to plaintiff's petition in the above styled and numbered cause in this statutory admiralty court, and would present to the court our answer as follows. That number 1, that this action is barred by res judicata. Number 2, plaintiff have admitted in their petition that they received the UCC1 financing statement, true bills, and affidavit, and totally and willfully refused and failed to answer the same. In doing so, they acquiesced and submitted through default to the Uniform Commercial Code presentment, which requires an answer within time allowed as the same as the statutory court. The plaintiff's willful default under the Uniform Commercial Code is not providing an answer or preserving their Uniform Commercial Code rights granted the default under the code. They have no right or standing to file this action. Had they looked at Anderson or O'Quinn's or Gould's Uniform Commercial Code official text and official comments, they would have been apprised of their rights and obligations. The plaintiff did not assert their rights and defense under the Uniform Commercial Code, and so waived their rights to complain or bring this action. They have to make a claim, their reservation of rights, as stated in UCC 1-207, UCC 1-103.6, states, the code is completely complementary to common law, which remains in force, except where displaced by the code. A statute should be construed in harmony with the common law, unless there is a clear legislative intent to abrogate the common law. Reservation of Rights 1-207 allows on one to insist that the statute be construed in harmony with the common law. UCC 1-103.6 states the code cannot read to preclude a common law action. The UCC 1 and UCC 3 filed by the defendants preserve their rights by stating UCC 1-207 without prejudice. Plaintiffs were required to answer the UCC presentment, and in not so doing, they refused their opportunity to deny and the viability of the presentment for implied contracts and warranties which are provided for under the code. Defendant deny all allegations against them. Plaintiff should have checked the Uniform Commercial Code, wherein defendants herein were given the right to sign debtor's name by accommodation. In any event, at one time, can it be said there could be, is accompanied by, can it be said by, there could be forgery when a signature is accompanied by the word by. The signer's own signature. This is provided for under the Uniform Commercial Code, under which plaintiffs and their attorneys operate. Plaintiffs' ignorance of the law and the Uniform Commercial Code under which they live, breathe, and operate is not a defense or a cause of action for them. Plaintiffs herein did not reserve their rights under the Uniform Commercial Code by answering, but totally refused to do so, and ignored the UCC claims sent to them, and they have no right to complain now after their willful default. Plaintiffs' assertion regarding UCC 9201 and UCC 9203 would not have applied and does not under their willful default, and UCC 9402 is one section that gives the right to sign debtor's name by accommodation. Their failure to assert their defense, if any, has barred plaintiffs from bringing this action. They have admitted in their petition that they have no remedy at law, and this is not an equity court. That the substance of this action was determined and tried in the Court of the Common Law on July 23rd, 1995, and judgment rendered that day on the Uniform Commercial Code, filing wherein plaintiffs herein were notified the same would be heard, and that once more they forfeited their rights to complain or to defense by ignoring that notice and refusing to answer the defendant. Exhibit attached. 10. This cause of action is barred by res judicata, and this statutory court has no jurisdiction and or venue over this substance as per the Constitution of the United States of America and the Bill of Rights in the separation of common law courts and statutory maritime courts, wherein it is specifically declared that there is no appeal from a jury trial in common law courts tried by a jury. It is well known that appeal is allowed from statutory court. The plaintiffs herein appear to be guilty of the criminal act of breaking and entering and burglarizing the office of Jerry L. Wilkins, attorney at law, the office of F.R. Johnny Johnston, and the office of Lakeview Developers Incorporated, in that Valerie Williams allowed a video of her to be filmed while in the above named office at night after working hours and aired same on television. They have attached unsigned and unfiled copies of the UCC papers that were in the office before they were sent for filing with the Texas state. These unsigned copies were obviously not sent to the plaintiffs herein. Plaintiffs themselves have declared and stated and admits in their petition in Court 2, number 22, that they have no remedy at law, meaning the legislative statutory courts. In their count 4, number 5, page 7, they have made and recognized the designation between the common law and the statutory law, and leave recognized the action of common law courts. Plaintiffs have absolutely no standing to bring this action since res judicata applies and this court is without jurisdiction over the matter. Wherefore, defendants herein have asserted their reservation of rights, UCC 1-207, do hereby request and assert their rights to have this case dismissed for lack of jurisdiction and venue and upon res judicata. Comes now, defendant. This is the motion to dismiss with brief. Let's see if it's a duplicate here. It's not a duplicate. We'll read it. Motion to dismiss brief comes now to defendant Jerry L. Wilkins, Fr. Johnny Johnston, and Lakeview Developers Incorporated, and moves to dismiss this cause of action pursuant to the lack of jurisdiction over the subject matter. This court lacks jurisdiction since the subject matter has previously been adjudicated by a court of competent jurisdiction from which there is no appeal, invoking res judicata. Furthermore, plaintiffs refuse any rights that they may had in refusing to answer the presentment that they admittedly received and admittedly did not answer. Plaintiff's original petition for declaratory judgment, injunctive relief, and other remedies. Plaintiffs A.H. Bello Corp. Bello, B-E-L-O, WFAA TV, Incorporated, WFAA, Robert W. DeBach, Decherd, and Valerie Williams, collectively plaintiffs, filed this original petition for declaratory judgment, injunction for relief, and other remedies, complaining that Fr. Johnny Johnston, Jerry L. Wilkins, and Lakeview Developers Incorporated, DBA, Lakeview Cemetery, Lakeview collectively defendants, and for their cause of action shows as follows. Parties. Plaintiff Bello is a Delaware corporation authorized to do business in Texas, having its principal place of business in Dallas County, Texas. Plaintiff WFAA is a Delaware corporation authorized to do business in Texas, having its principal place of business in Dallas County, Texas. Plaintiff Decherd is an individual residing in Dallas County, Texas, and Plaintiff Williams is an individual residing in the Dallas County, Texas. Plaintiff's original petition for declaratory judgment, injunctive relief, and other remedies. Defendant Jerry Wilkins is an individual resident of Dallas County, Texas. Williams may be served with process at this address. I'm not going to read the address. Defendant Fr. Johnson is an individual resident of Ellis County, Texas, and may be served with process at his residence, and I'm not going to read the address. Defendant Lakeview Developers Incorporated is a Texas corporation with its principal place of business in Ellis County, Texas. Lakeview Developers, Inc. May be served by its registered agents, Fr. Johnny Johnston, on the highway. All right, it gives an address. Jurisdiction in the venue. This court has jurisdiction over this matter in that the amount in controversy is within constitutional limits of the court. Venue is also proper in Dallas County pursuant to section 15.001 and 15.017, the Texas Civil Practice and Remedies Code. In the cause of action alleged herein occurred in whole or in part in Dallas County, Texas, and plaintiffs reside in Dallas County, Texas. Factual background. On information and belief in September 1994, defendants Fr. Johnny Johnston mailed to Bello and Decherd certain state of the forum common law UCC 1-105 non-negotiable true bill. In the true bills, defendants allege that Bello, DBA, WFAA TV, DeChurch and Williams, among other things, had engaged in a course of conduct constituting a breach of trust in connection with a certain news story done by WFAA and Williams. The true bills allege that the plaintiff caused defendants damage for the sum certain amount of $100 billion. Excuse me, $1 million. I don't know where I'm getting... no, it says $1 billion. That's $1 billion. $1 billion of constitutional money in species, minted coin or silver, original treasury production for these 50 United States. 10. The true bills request that plaintiffs, in order to settle this private claim quickly under Rule 16 pretrial, sign a private security agreement within 10 days of the presentment of the true bill. The private security agreement was in the form of a UCC1 financing statement. None of the plaintiffs signed a private security agreement or otherwise responded to the true bill. The true bills were never filed in any court of competent jurisdiction. None of the plaintiffs have ever incurred a debt as to any of the defendants, neither have they granted to any of the defendants any form of securities interest or signed any form of security agreement. On or about September 7, 1994, defendants filed or arranged to be filed certain UCC1 financing statements number 94176357, 94176358, and number 94176359. With the Office of the Secretary of State of Texas. The statements list plaintiffs as debtors and attach copies of the true bills. The statements contain signatures on line 9, signatures of debtors. The purport to be the signature of DeChurch. The signature are not DeChurch and on information and belief are forgeries. DeChurch did not authorize any person to sign in his name on any financial statement at issue. The financing statement represents that defendants have security interest in all personal and private property, cars, trucks, vehicles, land, real estate, buildings, businesses, apartments, buildings, and etc. Assignment of all stock, bonds, and certificates of deposit, signatures, all tangible and intangible property, and including but not limited to their partner's assets. All inventory, all retirement accounts while in public office, all inheritance, all accounts receivable, all salaries, all wages, until full accord and satisfaction has been paid over to the secured party paid in full. Each of the financing statements purportedly has been assigned to one of the defendants. On or about October 24th, 1994, October 18th, 1994, and November 29th, 1994, defendants filed or arranged to be filed with the Texas Secretary of State certain amendments to the financing statements numbers 94176357, 94176358, and 94176359, respectively. As part of each of these amendments, defendants filed or caused to be filed certain commercial liens, numbers 94728052, 94724855, and 94732510, respectively. Each of the commercial liens supports to place a lien in the amount of $1 billion on the real and personal property of plaintiffs wherever situated in any country, state, county, town, or city. Each of the commercial liens is signed by one of the defendants as lien creditor. Cause of action, count 1, declaratory judgment. Plaintiffs incorporate by reference paragraphs 1 through 17 herein, plaintiffs' rights, status, and other legal relations have been affected by Texas Business and Commerce Code, section 9.201, 9.203, and 9.402, in that the security agreement, financing statement, and commercial liens filed by each of the defendants purport to be valid under sections 9.201, 9.203, and 9.402, and each is invalid and fraudulent. None of the defendants have valid security interest in any of plaintiffs' assets because the requirements of subsection 9.203 and 9.402 have not been met to create either an enforceable security interest, sufficient financing statement, or a valid lien. Plaintiffs request that the court declare that none of the defendants have a valid security interest in any of the assets of any of the plaintiffs. Plaintiffs request that the court declare that each of the financing statements filed by defendants, each of which was subsequently assigned to another of defendants, and each of the commercial liens does not comply with the Texas Business and Commercial Code, including sections 9.201, 9.203, 9.402, and is invalid. Plaintiffs have retained the undersigned attorney to represent them in this action and have agreed to pay the firm reasonable and necessary attorney fees pursuant to Texas Civil Practice and Remedies Code, subsection 37.009. Plaintiffs are entitled to their cost and reasonable and necessary attorney's fees related to this proceeding under the Declaratory Judgment Act. Count 2, mandatory injunction. Plaintiffs incorporate by reference paragraph 1 through 23 therein, defendants' action in filing invalid and fraudulent financing statements and liens against plaintiffs' assets has caused continuing and irreparable harm to the businesses and reputations of the plaintiffs. As a result of the actions of the defendants, plaintiffs are threatened with the immediate loss of businesses or business. Plaintiffs have suffered and will continue to suffer injury to their business and reputation as a result of the cloud on the title to the plaintiff's assets. Plaintiffs have no adequate remedy at law to address the harm and damages caused by the defendant. Plaintiffs request that to address completely and appropriately the harm caused by the filing of the financing statement and commercial liens, the court issues a mandatory injunction requiring defendants to file termination statements with respect to each of the financing statements, numbers 941763357, 941763358, 941763359, requiring defendants to file release of the commercial liens, numbers 947280052, 9472485, 947325510, and requiring plaintiff's original petition for declaratory judgment, injunction for relief, and other remedies. Defendants to disclose the filing of, number, and place of filing of all financing statements, amendments, or financing statements and commercial liens in whatever form which any of the defendants has filed against the plaintiff. Plaintiffs are entitled to injunctive relief. Absent such relief, they will suffer irreparable injury for which there is no adequate remedy at law between the time of the hearing on the injunction and the final trial. It is likely that the plaintiffs will prevail at a trial on the merits because defendants can show no basis in law for filing a UCC-1 financing statement or any lien based thereon when no consensual security agreement exists. Count 3, tortious interference with economic relations. Plaintiffs incorporated by reference paragraphs 1 through 28 herein, subsequent to the filing of the financial statement and the commercial liens, plaintiffs attempt to conduct business in Dallas County. Defendants' actions in filing the invalid and fraudulent financing statements and liens have interfered or are calculated to interfere with plaintiffs' business relationships. Defendants' actions in filing and failing to release the financing statements and liens have caused plaintiffs damage in excess of the minimum jurisdictional limits of this court. In addition, the activities of the defendant as set forth herein were aggravated by the kind of willfulness, wantonness, and malice for which the law allows the imposition of exemplary damages. Defendants' activities were undertaken knowingly, willfully, and intentionally without jurisdiction or excuse, and they acted with gross indifferences to the right of plaintiffs accordingly. Plaintiffs seek punitive damages for from defendants. Now remember, the defendants prevailed in this. Plaintiffs incorporated by reference, this is count for attorney's fees. Plaintiffs incorporated by reference paragraphs 1 through 36 herein pursuant to the Texas Civil Practice and Remedies Code, subsection 37.009, The plaintiffs are entitled to recover their reasonable and necessary attorney's fees expended in the matter. Wherefore, Plaintiffs Bellow, WFAA, the Church and Williams pray the defendants each be cited to appear and answer herein, and that after such time the court grant relief to them as follows: a declaration to no valid and enforceable security agreements existing between any of the defendants and any of the plaintiffs, a declaration that each of the financing statements 94176357, 94176358, and 94176359 filed against the plaintiffs is invalid and fraudulent, a declaration that no valid and enforceable lien in favor of the defendants exists on any property of plaintiff, a declaration that each of the liens 94728052, 94728555, and 94732510 filed against plaintiff is invalid and fraudulent, a declaration that plaintiffs are entitled to statutory and common law damages as a result of the wrongful filing, a declaration that plaintiffs are entitled to their cost in this action and the reasonable and necessary attorney's fees incurred, a declaration that the judgment entered in this cause be filed of record with the Secretary of State. A permanent mandatory injunction requiring defendants to file termination statements as to the financial statements numbers 94176357, 94176358, 94176359, requiring defendants to file release as to commercial liens number 94728052, 94724855, and 94732510, and requiring defendants to disclose the filing of number and place of the filings of all financing statements, amendments of financing statements, and commercial liens in whatever form which any defendant has filed against any of the plaintiffs. Judgment against the defendants for actual damages incurred, exemplary damages, prejudgment interest at the maximum rate allowed by law, and such other and further relief that justice may require. Respectfully submitted by Jenkins S. Lynch, a professional corporation. So, in knowing all of that and everything that they filed, it's pretty clear this right here holds a lot of weight. Order of dismissal. It is hereby ordered that this cause of action is hereby dismissed for lack of jurisdiction, since the subject matter has previously been adjudicated and res judicata does apply and bars this action. Why is res judicata important? Because it was executed in a proper venue, the original court of competent jurisdiction, where it was a trial by way of jury. The Magna Carta of the year 12,015 in England stated that the basis for the common law, this law was brought to America when English sovereigns came to American shores. Common law was the supreme law of the land of America and was thereby our Supreme Court of the people, by the people, and for the people. Then came the Constitution of the United States, dated 1787, September 17th, 1787. Which is still in effect and has never been declared void, and is the oldest written constitution still in effect today, wherein Article 1, Section 1 states, all legislative power herein granted shall be vested in a Congress of the United States, which shall consist of the states, the Senate and the House of Representatives. Section 8, it states that Congress shall have power to constitute tribunals inferior to the Supreme Court. The Constitution had not, prior to this statement in the Constitution being written, since this was Article 1, provided for a legislative Supreme Court. They were and could not, without any doubt, be referring our one Supreme Court and in and of common law, which was already established and active in America and the United States of America. It is clear that the Constitution was now setting up another set of courts called legislative courts, and they refer to them as inferior courts, meaning inferior to the already existing common law courts of our one Supreme Court. Article 1 of the Constitution did then and there set up legislative courts inferior to the common law courts, and is verified by Article VII of the Articles of Amendments to the Constitution, wherein it guarantees that in suits at the common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no facts tried by a jury shall otherwise be reexamined in any court of the United States than according to the rules of the common law. This sets the court of common law separate and apart from legislative courts, such as the 14th Judicial District Court, otherwise being a maritime court, in that any case tried in the 14th District can be reexamined by action on appeal. This places the 14th District Court as one of the inferior courts referred to in Article 1, Section 8, the Constitution of the United States. Note, the difference in a trial by jury in the common law as to a trial with a jury in the legislative inferior courts. The judge is in the inferior courts and instructs the jury on what they will hear and decides upon and what they will not. There is no such provision in the common law with trial by a jury. The Northwest Ordinance of 1787, which have never been altered by the common consent on or in any way or manner, and presently remains in force. The last words of the introduction of the preamble to the articles of the ordinance state, "It is hereby ordained and declared by the authority aforesaid that the following articles shall be considered as articles of the compact between the original states in said territory and shall forever remain unalterable unless by common consent." Thanks for joining me.